Hello and a warm welcome to the 15th edition of your favorite channel, Human Rights Heroes. Imagine that you resume duty and are told to leave immediately. No notice, no prior warning. You have been fired. You have been dismissed. Well, if this is surprising to you, this is a fate which many Nigerian workers, especially in the private sector, have suffered and still suffer. I am sure that if you are not the one, that at least you know someone who have been fired, who have been dismissed without notice. But our focus question today is it lawful? Is dismissal overnight? Is sudden dismissal lawful? In this video, we shall be answering these questions. Remember that this is half an hour with the Human Rights Wizard, your usual anchor, Ogochukwu Honor. So we begin by briefly talking about some practical examples, that is, some real examples of overnight or sudden dismissal. The first one was a personal experience. I witnessed it happen in an organization where I was a staff. A worker resumed duty in the morning and was a few minutes late. And the proprietor, the business owner, walks him out of the gate. And that was the end of the matter. He had been dismissed. There was no prior notice. In the same organization, a staff was dismissed at a meeting. The meeting was summoned purposely to dismiss the staff and to make the dismissal disgraceful by making it happen in public. What did the staff do? The staff had commented in private that the business owner, the employer, and some management staff had no respect for the staff because of the way they treated the staff. And the employer summoned the meeting, repeated what the employee said, and announced that she had been dismissed. In the same organization, two other dismissals also happened suddenly. It was a secondary school. And the third of this dismissal happened to the vice principal of the school. The employer summoned a meeting and announced that the vice principal had been dismissed. The vice principal was there. He said, "You know this man, he's our vice principal. I want to tell you that he is hereby dismissed." What did he do is immaterial. There is no provision in the law that permits an employer to dismiss a staff or a worker. So summarily, whatever the offense was, there are rules, there are procedures, there are laid down steps that must be taken before the dismissal can be effected. Then the fourth one was because the teacher, he was a teacher, committed a grammatical blunder. The employer heard him on 2 occasions, so he reported, speak what he considered a grammatical blunder, and he walked into the staff room one afternoon and told him to leave the premises. He had been dismissed. In my 11 years or more of working with human rights organizations, as a volunteer, we have received scores of reports bordering on this kind of illegal dismissal. In one such case, involving a school also, another school in the same town, the worker was a part-time teacher, and the employer had besought him, had begged him to change his part-time status to a permanent one, but he declined. And the employer said that he would have to look for a more permanent staff, and told him that if the permanent staff was engaged, that he would be disengaged. Of course, there's nothing wrong with that. But everything is wrong with the manner, the procedure through which this was effected. So the employer engaged a permanent staff to replace the part-time staff. Of course, the part-time staff was not aware of this. So one morning, as he was reporting to work, as soon as he entered the gate, the employer was there and told him to walk away. He had been dismissed. That worker came to a private human rights organization where I worked as a volunteer and reported the matter. Happily, through the ADR process, alternative dispute resolution, the matter was resolved. The employer was invited, and he was told how he had broken the law and trampled upon the rights of his employee. Eventually, the human rights organization got the employer to pay some compensation to the employee along with his salary for the month. And so, cases of this nature happen repeatedly in Nigeria. And in this video, we want to begin by telling you that something can be done. It is not a situation that calls for silence. You don't slip over your rights. So now we talk about what the law says about overnight dismissal or sudden dismissal. What does the law say? The law in question here is the Labor Act. The Labor Act is a statutory instrument, that is a law of the Nigerian Parliament that regulates the working relationship between an employer on the one hand and the worker or employee on the other hand. What does the labor law say about dismissal? First of all, if there is a contractual agreement between the worker and the employee, then we say that there is a contract of employment. And the provisions of this contract bind the two parties. Now, assume that one of these parties wants to terminate the contract. The law provides that the party involved has to give some notice, has to serve the other person, the other party, with a notice. If, for instance, the employment has lasted for 3 months or less than 3 months, then the worker, employee, or the employer should serve a day notice, 1 day notice. What I'm trying to say, in effect, is that the employer can terminate the contract. The employee can also terminate it. The party that desires to terminate the contract gives the other party a day notice if the employment has lasted for 3 months or for a period less than 3 months. That's the first one. Now the second, if the employment has lasted for more than 3 months but less than 2 years, then the party who wants to terminate the employment should serve the other a week's notice That is, if the employer or employee wants to terminate the contract of employment that has lasted for more than 3 years but not up to 2 years, that's for more than 3 months but not up to 2 years, then the one who wants to terminate the employment should serve the other a week notice. A week notice. Number 3, if the employment has lasted for 2 years but not up to 5 years, then the party that wants to terminate it should serve the other a month's notice. That's a notice of 2 weeks, I beg your pardon. Should serve the other a 2-week notice if the employment has lasted for up to 2 years but less than 5 years. For more than 2 years but less than 5 years, then the party that wants to terminate it should serve the other a notice of 2 weeks. However, that's number 4. If the employment has lasted for 5 years or more, then the party that wants to terminate it should serve the other a month's notice. Now let's go through all of these again. A day notice is lawful. A week's notice is lawful. A 2-week notice is lawful. A month notice is lawful, finally. Should we go through that again? A day notice, if the contract of employment has lasted for 3 months or less. A week notice, if it has lasted for more than 3 months but less than 2 years. A 2-week notice, if it has lasted for 2 years or more but less than 5 years. And then a month notice, if the employment has lasted for 5 years or more. What else should we know about what the law provides? If the notice is of a week or more, it must be in writing. So a day notice can be spoken. But if it is a week or more, a week, 2 weeks, or 1 month, it must be in writing. That's one of the rules. What else? The party issuing the notice, has certain regulations to observe. For instance, the employer issuing the notice must pay the worker for the period which he ought to have worked if the notice had not been served. So if a month's notice is issued, it does not automatically terminate the employment of the worker. The worker continues to work and has to be paid at the end of the month. Then it is also possible that payment can be made. The party issuing the notice can pay instead of issuing the notice. So a worker can accept payment. Assume the job is to be terminated suddenly, as we're talking about. The employer could decide to pay the worker for damages, for the injury caused by the sudden termination, along with his monthly salary for the month. This is also a provision of the law. And what is next? Now let us talk about when sudden dismissal is acceptable in the law. If a worker takes an action which, before the Labor Act came into existence, might have resulted in the employer terminating the contract abruptly or suddenly, then it is acceptable by the law. That a worker has done something that, in the absence of the Labor Act, the employer would dismiss the worker without notice, then that dismissal is acceptable. I am sure that is technical, but in practice, it rarely happens, except that some employers simply violate the rights of workers by summarily dismissing them when there is really no such offense as would have warranted such a dismissal when the Labor Act was not in existence. So that is when sudden dismissal or overnight dismissal is acceptable by the law. When is it unlawful? When is it not accepted by the law? When any of the conditions I enumerated concerning notice is not observed, then the sudden termination of the job is unlawful. Now, there is no action, there is no offense, there is no conduct whatsoever that will warrant the dismissal of a worker, and then he is suddenly dismissed. For instance, for expressing an opinion on an issue. Section 37 of Nigeria's Constitution as amended talks about the right to freedom of speech. If a worker expresses his or her opinion concerning the behavior of the employer, it's just an opinion and he's got the right, then the employer dismisses the staff suddenly. That is unlawful. If a worker arrives in an organization late coming is an acceptable practice in all industrial sectors around the world. There is no place around the world where workers do not report to work late. Sometimes even employers do so equally. So it is not a ground for the sudden dismissal of a staff. There are rules about fining a staff for coming late to work, for leaving his or her job before dismissal, and for similar offenses. There are laws providing for how the staff is to be punished or penalized. And none of these prescribes a sudden dismissal. So sudden dismissal or overnight dismissal is against the law. Lastly, we want to talk about remedies. Before we talk about remedies, that is, what can you do if you or someone you know is dismissed overnight? Before we talk about this, remember that although sudden dismissal can happen among workers, it is unlawful. The law still speaks, even though some employers might do what they deem necessary. Like this video and share it if you've enjoyed what we're doing, and subscribe to this channel so that you encourage us to do more. Help us make this video have a wider reach. That is something you can do for us. If you do that, you will have contributed in propagating the message of harmony, orderliness, and lawfulness in our society. Do not sleep over your rights. What do we mean by that? Do not die in silence, cry in your bedroom, and try to leave everything in the hands of God. That is not permissible. God has equipped us to fight our cause. God cannot do for us what we can do for ourselves. So if you have a problem like the one we're talking about here, ask questions. Ask one or two persons. Before you ask the third person, you get help. You get someone who will refer you to a place where help can come. First of all, we need to know that there are agencies that can help resolve this kind of a problem. The first is the National Complaint Bureau. National Complaint Bureau or National Complaint Commission. It's a federal government establishment that settles disputes arising between employers and employees, especially if the organization is registered with the Corporate Affairs Commission, CAC. Apart from these, there are other human rights bodies like the National Human Rights Commission, where you can lodge your complaint. And away from these, there are many privately owned human rights organizations that assist Nigerians who face human rights problems to fight for and reclaim their rights. This channel is not an enforcement agent, but this channel is, that is Human Rights Herald, is affiliated with many human rights organizations, privately owned, and those that are owned by the government. What you need is to call on us if you have no other person to report to. Call on us, send us an email at humanrightsherald.wizard@gmail.com, or you can leave a comment on the comment section and tell us what really is the problem. You can also call the hotline 0806 5422 624, or send me a WhatsApp post on 091 333 01790. Then I'll link you up to a human rights organization that can help you reclaim your right as a worker, where such a right has been trampled upon by your employer. These human rights organizations provide pro bono service, that is, they provide free legal service. Because one problem which hinders workers from fighting for their rights is money. The financial wherewithal with which to hire a legal representation. In these human rights organizations, pro bono service means free legal service. They will provide you with a lawyer who will stand for you in a law court. The Nigerian Legal Aids Council is another organization established by the federal government to provide free legal service to Nigerians who are indigent, to Nigerians whose rights have been trampled upon and who have no money to hire legal representation. These are some of the steps you can take towards fighting for your rights. The human rights organizations do not usually go to court straight away. First of all, they will follow the ADR, Alternative Dispute Resolution. Your employer will be invited along with you to have the issue resolved and compensation paid to the injured party. It is only when this process fails that the organization resorts to litigation or to lawsuit. Remember, like I said earlier on, sudden dismissal is unlawful, though it may persist. It is unlawful. And it is your duty and I to learn how to say no to it and then take advantage, avail ourselves of the legal remedies available when this happens. Remain lawful and stay away from trouble. And remember our slogan here: know your rights, protect your rights, and defend your rights. I thank you for being a part of this today. Goodbye.